I'm loath to bring an individual's personal life into the discussion, but the hypocrisy of someone who has been married 4 times and divorced 3 times challenging the sanctity or validity of anyone else's marriage is staggering. Hi, everyone. I'm Joss with another LGBT Alliance USA News Roundup for the week ending August 18, 2025. Today, I'll cover the following stories. You'll hear an Amy Hamm case update over gender-critical speech. Riverside Poly forfeits volleyball match over trans-identifying male athlete competing in female category. Federal appeals court lifts injunction on Arkansas's 2021 SAFE Act. And finally, Kim Davis, who has been married 4 times, twice to the same man, and divorced 3 times, is still very, very upset about marriage equality for same-sex couples. Since I'm flying solo today, I want to begin by sharing some information from our friends at WDI USA about their upcoming convention. They sent this message to us. WDI USA is excited to invite you to our 4th annual convention from September 19th through the 21st in Indianapolis, Indiana. This year, our focus is on growing the women's liberation movement. Topics covered will include advocacy for incarcerated women, the fight for abortion rights, combating misogynoir, creating in-person women's groups, the effects of pornography on women, successes in the fight to protect women's sports, and what's next for detransitioners. The convention will be followed by an action at the NCAA Hall of Champions in support of women's sports. This is a women-only event, and you have until August 31st to register. So please check that out. The link to their website will be listed in our show notes. Moving now to an update on Amy Hamm's case. A disciplinary panel of the British Columbia College of Nurses and Midwives has suspended registered nurse Amy Hamm for 1 month and ordered her to pay $94,000 in legal costs after finding her guilty of professional misconduct for social media posts and a billboard declaring "I heart J.K. Rowling." The college ruled that Hamm's statements on sex, gender, and transgender issues made while identifying herself as a nurse breached professional standards and risked harm to trans-identified persons. Hamm first attracted the college's attention in 2020 when she helped fund a Vancouver billboard supporting author J.K. Rowling. An inquiry committee launched an investigation that culminated in a 332-page report examining Hamm's tweets, opinion pieces, and other online remarks. The matter proceeded to a 20-day hearing over 19 months. During the hearing, the panel highlighted 4 instances in which Hamm wrote or shared comments deemed quote-unquote discriminatory and derogatory. Among them was a post warning that, quote, trans activists determined to infiltrate or destroy women-only spaces, end quote, and, quote, is there anything more embarrassing than straight people going by they, them, getting a dumb haircut, and calling themselves trans and queer, end quote. The college found these statements unacceptable when attributed to a registered nurse. Although no person has filed a complaint or demonstrated any direct harm, the panel concluded that the likelihood of trans-identified people would find her statements discriminatory was sufficient to warrant discipline. Hamm's legal team argued that the case punished her for the risk of harm rather than any actual injury, and noted that the complaints were ideological rather than from patients. Expert testimony played a significant role in the decision. Dr. Greta Bauer, a professor of epidemiology and biostatistics at Western University and sex and gender science chair for the Canadian Institute of Health Information, was paid $38,000 for her testimony. In her testimony, she supported use of inclusive language, such as birthing people, and challenged the view that there are only 2 biological sexes. Hamm, a single mother and nurse for 13 years with an otherwise unblemished record, was dismissed by Vancouver Coastal Health without severance following the panel's ruling. She remains unemployed in nursing. Hamm told the panel that imposing substantial penalties for expressing conscience-driven views would deter health professionals from engaging in public debate on controversial issues. The case has drawn criticism from free speech advocates and some legal experts who argue that professional bodies are overstepping their mandate by policing off-duty expression. Further, critics argue that Hamm is being penalized for saying out loud in 2020 what many around the world are saying now. In a recent United Nations report, Special Rapporteur Reem Al-Salem warned that conflating sex, gender, and gender identity undermines sex-based protections for women and girls, echoing concerns similar to those Hamm raised. Critics say the college's decision sets a chilling precedent. suggesting that nurses and other professionals in Canada may face severe financial penalties for expressing dissenting opinions. While Canada's charter guarantees freedom of expression, this ruling would seem to illustrate otherwise. Hamm maintains that her comments were truthful rather than hateful. In a statement, she asserted that biological reality matters, and so does freedom of expression, and expressed gratitude to thousands of Canadians who continue to support her legal challenge through donations to the Justice Center for Constitutional Freedoms. Now, moving to sports news. Riverside Poly High School announced it would forfeit Friday's non-league girls volleyball match against Jurupa Valley High School, recording the game as a loss. The school's brief statement offered no explanation, but emphasized its commitment to a safe, positive environment for all student athletes and expressed regret for disappointing families and supporters. Multiple parents of Riverside Poly players said the forfeit was a deliberate protest over fairness and safety, citing Drupa Valley's roster, which includes trans athlete A.B. Hernandez. A father, Fred Brayton, said the decision wasn't rooted in hatred, but in a belief that girls' sports should be reserved for biological females, and that the players themselves chose not to compete. An anonymous mother on the junior varsity team echoed concerns for her daughter's safety, calling the girls' stand bold and a clear message about keeping boys out of girls' athletics. Riverside Unified School District Board member Amanda Vickers confirmed the students' reluctance to play, noting some parents wore Save Girls Sports shirts in anticipation of the game. Vickers referenced the 2022 injury of former player Peyton McNabb, who suffered permanent brain damage after being struck by a spike from a trans athlete, as a cautionary example underscoring the perceived risks. She said, quote, "There is a difference between biological girls and biological boys, and tonight the girls of Riverside Poly High School, they're not going to end up like Peyton McNabb." End quote. Drupa Unified School District issued a statement confirming Riverside Poly's cancellation without disclosing reasons and offering no further comment. The forfeit adds to ongoing controversy in Riverside County, where two female athletes displaced by a trans-identified male athlete at Martin Luther King High School sued the school last year and, after Hernandez's breakout track season, sparked widespread complaints and protests. During Hernandez's state championship run in May, opponents donned Save Girls sports shirts and even prompted a last-minute California Interscholastic Federation policy tweak to elevate female finishers who placed behind a trans athlete. In July, the U.S. Department of Justice sued the California Department of Education and CIF over policies allowing biological males to compete in girls' sports. A recent Public Policy Institute of California survey found strong public bipartisan resistance to trans-identifying males competing in the women and girls sports categories. 65% of adults and 71% of public school parents believe trans-identifying athletes should compete according to their sex, not their gender identity. Now turning to an update on the 2021 Arkansas SAFE Act. A federal appeals court on Tuesday lifted the injunction blocking Arkansas's SAFE Act, clearing the way for the state to enforce its ban on gender-related medical treatments for trans-identifying minors. The 8-2 decision from the 8th U.S. Circuit Court of Appeals follows Arkansas Attorney General Tim Griffin's request to consider the U.S. Supreme Court's recent decision upholding Tennessee's similar law in U.S. v. Scrimeti. The ruling ends 4 years of litigation and allows the SAFE Act's restrictions on puberty blockers, hormones, and surgeries to take effect. The SAFE Act, also known as Act 626 of 2021, initially faced a challenge from 4 families of trans-identifying minors, which prompted an injunction in July 2021 by U.S. District Judge James Moody. After an 8-day trial, Moody found the law unconstitutional in June 2023 on First and 14th Amendment grounds, faulting the state for failing to show that gender-related treatments were unsafe and ruling that the act discriminated based on sex. The plaintiffs, represented by the ACLU of Arkansas, argued that the law deprived parents of their right to direct their children's medical care and singled out trans-identified youth. In reversing Moody's decision, the Eighth Circuit applied a rational basis review, concluding that the SAFE Act regulates medical procedures by age and type rather than discriminating on the basis of sex. The court rejected the district judge's view that prohibiting physicians from referring patients for gender treatments infringes on free speech, citing Supreme Court precedent that allows states to regulate professional conduct even when it incidentally involves speech. The appeals ban also held that parents do not have unlimited authority to make medical decisions for minors and found that Arkansas presented a legitimate interest in protecting children. ACLU of Arkansas Executive Director Holly Dickinson condemned the ruling as quote-unquote tragically unjust and pledged to explore further legal strategies. Meanwhile, Attorney General Griffin celebrated the decision, asserting that the state has a compelling interest in shielding children from, quote, risky experimental procedures with lifelong consequences, end quote. Griffin and the law's primary sponsors, State Rep. Robin Lundstrom and State Senator Alan Clark, stressed that the legislation was driven by concerns for minor safety and the belief that gender dysphoria warrants psychological evaluation rather than immediate medical intervention. Arkansas became the first state to pass such a ban in 2021, a model later adopted by 26 other states, including Tennessee. In 2023, Arkansas lawmakers also enacted the Protecting Minors from Medical Malpractice Act, which created a 15-year window for malpractice lawsuits against doctors who provide trans-identifying minors with any of the same treatments the SAFE Act sought to ban. In 2025, they added mental health care professionals to the list of medical providers who could be sued. Finally, wrapping up with some information about Kim Davis and her Supreme Court challenge. The Supreme Court will decide this fall whether to review a petition explicitly seeking to overturn its landmark 2015 decision in Obergefell v. Hodges, which guaranteed same-sex couples the right to marry nationwide. The petition comes from Kim Davis, the former Kentucky County Clerk jailed for refusing to issue marriage licenses to a gay couple on religious grounds, who now challenges a $100,000 jury verdict for emotional damages and $260,000 in legal fees. Davis's petition argues that the free exercise clause of the First Amendment shields her from personal liability in denying marriage licenses. More fundamentally, her legal team contends that Obergefell was, quote unquote, egregiously wrong and must be corrected. In their brief, attorney Matthew Staver labels Justice Anthony Kennedy's majority opinion a quote unquote legal fiction and emphasizes Davis's unique role as the first American jailed for, quote, following her religious convictions regarding the historic definition of marriage, end quote. Lower courts have uniformly rejected Davis's claims. A federal appeals panel ruled earlier this year that Davis cannot invoke the First Amendment in defense of state actions, and judges declined to rehear her appeal. Her opponents, including attorneys for the married couple David Ermolds and David Moore, regard her effort as a long shot and maintain that the High Court will find no merit in revisiting Obergefell. The petition arrives amid a broader conservative push to roll marriage rights back for same-sex couples. Since 2015, at least 9 states have introduced measures to block same-sex marriage licenses or called on the Supreme Court to reverse Obergefell. In June, the Southern Baptist Convention adopted overturning Obergefell as a denominational priority, reflecting ongoing efforts by social conservatives to reshape family law. Davis also invokes Justice Clarence Thomas's concurrence in Dobbs v. Jackson Women's Health Organization, in which he urged reconsideration of substantive due process precedents in Griswold, Lawrence, and Obergefell. Legal scholars say the comparison to Dobbs underscores the petition's strategy, yet most observers expect the justices to let challenges percolate through lower courts before taking up such a foundational question. The Supreme Court will privately consider Davis's petition at its fall conference and could decide not to add it to the docket, leaving lower court rulings in place. If accepted, the case could be argued in the spring of 2026 with a decision by the end of June 2026. Worth noting, Justices Brett Kavanaugh, Amy Coney Barrett, and perhaps even Neil Gorsuch show little interest in reopening the gay marriage debate. Even if Obergefell were overturned, it would not dissolve existing marriages. The 2022 Respect for Marriage Act, which held bipartisan support in Congress, was signed by President Biden and requires all states and the federal government to recognize all same-sex and interracial marriages. This excerpt now is from the uscourts.gov. Quote, the court usually is not under any obligation to hear these cases, and it usually only does so if the case could have national significance, might harmonize conflicting decisions in the federal courts, and/or could have potential value. In fact, the court accepts 100 to 150 of the more than 7,000 cases that it's asked to review each year. Typically, the court hears cases that have been decided in either an appropriate U.S. Court of Appeals or the highest court in a given state, end quote. Since the appeals court showed no interest in rehearing Kim Davis's case, and the Supreme Court almost always hears cases that have first been heard by an appeals court, I'm of the opinion that it's doubtful the Supreme Court will take a case the appeals court declined to rehear. Further, when we've spoken with legal experts like Candace Jackson and Glenna Goldis, they've indicated that altering the Obergefell ruling would impact contract law and ultimately open a massive can of worms. To me, it feels like this is settled law that would create more problems than it's worth to take on, especially with so few conservative justices seeming interested in the issue, and it would also require 4 of the 6 conservative justices to vote to accept the case. To expand a little more on Kim's background, I'll share this with you from Wikipedia. Like I mentioned in the opening, Kim Davis has been married 4 times to 3 husbands. The first 3 marriages ended in divorce. Davis has 2 daughters from her first marriage and twins who were born 5 months after her divorce from her first husband. Her third husband is the biological father of those twins, the children being conceived while Davis was still married to her first husband. The twins were adopted by Davis's current husband, who is also her second husband. The couple initially divorced in 2006, but later remarried. I'm loath to bring an individual's personal life into the discussion, but the hypocrisy of someone who has been married 4 times and divorced 3 times, challenging the sanctity or validity of anyone else's marriage is staggering. Well, what are your thoughts? Do you think the Supreme Court will take up Kim's case, and if so, why? Thank you for watching or listening to another news roundup. Please join us next week and be sure to like, comment, and subscribe. Share it to help us with the algorithm. And taking a note from Ty Rivera, if you're not sure what to comment, add the date of your anniversary, the number of years you've been with your significant other, or where you met, or just share your thoughts on any of the stories I covered today. Until next time.